All right, good morning, everyone. This morning, we are going to get some background information from Ledge Council around some of the questions that we've had around essentially long-term care planning. And this is related to H120. And I should let folks know that I have asked Representative Noyes to meet with Representative Iacoboni to sort of maybe restructure the bill a little bit more to look at as a report back to the committee, as opposed to just establishing things. So to be looking at, how this might be implemented in Vermont, what might the ramifications be, how it, options for potentially how it would be funded, how people would contribute to it. And then this morning, we're going to hear about some of the rules surrounding long-term care and Medicaid, because part of why this could be beneficial is to reduce the reliance on Vermont Medicaid into the future. So by increasing people's ability to plan for their future and future care. So good morning, Eric. Happy to have you here.
Good morning. Thank you very much.
I think this is your first time this session here.
It is, yeah.
So we'll just do a quick run around the room so you know who we all are. Teresa Wood from Waterbury and also serving local fuel score in Huntington.
Hi, I'm Ray Garofano. I represent Essex and Essex Junction.
Jubilee McGill from Bridport, and I also represent Middlebury, New Haven, and Weybridge.
I'm Zon Eastus. I live in Guilford and I also represent Vernon.
Good morning, Todd Nielsen, represent Brandon Forestdale.
Doug Bishop, representing Colchester's Chittenden 20 District.
Hi, good morning. Eric McGuire, represent Rutland City.
Good morning, Dan Noyes, represent Wolcott, Hyde Park, Johnson, and Belvedere.
And Donahue, Northfield, and Berlin.
Laurie, Force Committee Assistant. And Master Wizard. Especially if today's schedule.
Well, good morning. Nice to see everybody, and nice to be, and as the chair said, first time this session in this committee. So I spend most of my time in the Judiciary Committees, as you may or may not know. I'm part of our Judiciary team. So sometimes I will get up here depending on whether we have some crossover of issues. One session, it may be more often than another session, but this is my first time, so thank you. The reason I'm here is because of one of these crossover issues, actually. And I'm certainly not an expert in Medicare or long-term care, generally speaking, but I do cover probate issues for the Judiciary Committee. That means wills, trusts, estates, that kind of thing that are in the probate division of the Superior Court. And there is some crossover, some important crossover between a person's estate, which is the property they have when they die, and the ability of Medicaid to recover from a person's estate after they died any expenses that Medicaid paid for long-term care on behalf of the person while the person was still alive. So sometimes that will happen. And in fact, under federal law, under federal Medicaid law, every state has to have what's called a Medicaid Estate Recovery Plan. It's referred to as a MERP, M-E-R-P. Some people call it just M-E-R, but it's Medicaid Estate Recovery. And so it's even the name of it, if you think about the word estate, shows you why there's a crossover with judiciary issues. It's estate recovery. And the estate refers to, as I was mentioning, the property that a person has upon their moment of death when they pass away. So there's this overlap between the two things. And I know a little bit about that, which is, I think, why I'm here with this committee to explain some of that, because that certainly would be very relevant to the committee thinking about what it wants to do for long-term care generally. What is the state of the law now? So with that said, before, as the chair mentioned, also, in addition to having this Medicaid Estate Recovery Plan, which Vermont has, there are also rules in place. The Vermont Health Access, Department of Vermont Health Access has this Medicaid plan and rules that are specifically about how this recovery from a person's estate works. And I sent them to Lori, so you have them on your website. You can look at them when you want to take a look at the text. But before we do look at the language, which I think is important to do for a minute, just a couple of minutes of background to kind of ground people and, well, why, how did that before looking at the language, I think it might be helpful to understand what is this underlying thing that we're talking about with respect to states and the probate courts and all that. So, generally speaking, as I said, the Medicaid and the state Medicaid folks, and in Vermont, it's VA Department of Vermont Health Access, as well as they have actually a few attorneys at the Attorney General's office who work with them to participate in this process of asset recovery. And they have plenty of other things to do, so I'm not saying that's the only thing they do, but there are some folks who work on that issue. And that's what makes it important to think about, well, what can they recover? What assets are available to the folks at the AG's office and DBHA when they're looking at the estate of someone who passed away? So when someone dies, generally speaking, the probate division of the Superior Court used to be called the probate court before the judicial unification took place. Now it's called the probate division. They open an estate for a person. And the estate generally includes all the property that the person owned at their time of death. And so the probate division has jurisdiction to supervise the distribution of this property. So usually, perhaps if the person had a will, they would have named an executor who will help distribute their property. If they didn't have a will, which means they died intestate is the word. It's interesting to think it's an estate. If you die intestate, that means you didn't have a person named, or you didn't have a will. Sorry. And I always, as an aside, suggest you get a will. Because otherwise you're leaving it up to the state to decide who it is who's going to distribute your assets and who's going to get them. You can decide yourself, or state law, called the intestacy statutes. They specifically lay out if a person isn't without a will, here's how their property gets distributed. If you want to have your own say in how that happens, it's good to have a will.
Go ahead, Rip.
Back up for my plug for the legal community.
Sorry to jump in so quickly.
Please do.
But people can arrange their assets such that there's no need to go to probate court. So I guess maybe you'll get to this, but I'm curious how that plays into what the state program can and cannot do if someone has left beneficiaries for
Yes.
things held jointly, that sort of thing.
Yeah, they're very apropos questions. Exactly something I'm going to move right into, because it's also very important. Because as I was saying, the probate estate is all the property that a person owns upon their death. Again, so what's implicitly not included? What they don't own. But you might have a property interest in something. But if you're not the owner of it, there are certain legal mechanisms that a person can use to avoid probate. So think about, first of all, why would a person even want to do that? Well, probate can be both time consuming and expensive. So you might have to hire an attorney. The executor or the administrator is entitled to fees. Particularly with respect to, not always the case, but it's not unusual for a person who passes away to have their primary residence as really their main asset. It's not unusual that their primary asset is their home. And if you think about, well, if let's say that person has more than one beneficiary, they got a couple of kids or a couple of brothers and sisters or family members, whoever they may be, if that home has to go through the probate court process, that can be a complicated and time-consuming endeavor. To probate court, the executor or the administrator, as the case may be, would have to value that home, sell it, divvy up the profits, or whatever might be left over. If there was a mortgage on the home, whatever excess value there might be among the whoever it is that would be the beneficiary of it, time-consuming and expensive process. So some people, as an estate planning tool, this gets into the probate estate idea, because as I say, all the property that's in the estate, when the person dies, goes into the probate court. They have jurisdiction over it. It is valued. So first thing, you have to determine what's the value of all the property. Then you have to pay all the debts. Person might have had debts when they passed away, or they might have funeral expenses, and whatever debts might be owed are paid first. And then whatever's left over gets distributed among the beneficiaries. And this is all on as I say, can be a lengthy and detailed process that has to be gone through. So particularly with respect to a home, say someone of moderate means and their home is their only asset, they might reasonably think, and again, this is our estate planning approach. This is what we talked about in judiciary with a lot of estate planning attorneys when we're crafting the probate code. People might reasonably think, hey, if I have to go through all that with my one asset, my home, by the time all that's finished, there's not going to be anything left for the children or siblings or whoever it is that they wanted to get some of their be able to pass on some of their home to. So there are estate planning tools, and this is segueing into exactly what you're talking about. There are estate planning tools in order to keep, for example, the home in particular out of the probate process. And one of these is called, which you may recall if you've been here a couple of years, I know Representative Donahue recalls, I think we were chatting about it yesterday a little bit, what's known as a life estate. Okay? And now we have what's known as an enhanced life estate as of a couple of years ago. Life estate is a means of owning property jointly. More than one person own an interest in the property. So the way it works is you say, for example, are a person who's thinking about planning your estate and you have your home and you're thinking, I'd like to be able to transfer it to whatever, a couple of children, whoever it may be. But I don't want to go through that long, expensive probate process. So I can change the ownership status of the home. And this, by the way, life estate only applies to real estate. Doesn't apply to any other, whatever you may have, furniture, your car, whatever. It's real estate only. And the way it works is that the owner of the home while they're alive, retains the right to possess the home, to live in it, and to, in fact, under the new enhanced life estate law, they can also take out a mortgage if they want. They have more property rights than they used to have prior to the passage of that. But the main point is they have what's known as a life estate. So for the life of that person, they are able to live in the home. Upon the person's death, now, so whoever their beneficiaries are, let's just say for the sake of the example that it's two children. Let's say that person names these two children as the beneficiaries. So upon the person's, as it happens, my mother has a life estate and my brother and I are the two beneficiaries. So that's kind of what I know about that particular example. So when the property owner dies, upon operation of law, immediately upon their death, the property transfers to the beneficiaries, to the children, to the siblings, to whoever the person named as their beneficiaries immediately. So think about it. That means on the moment of their death, who owns the property?
Kids.
The kids. So does the property go through the probate estate? No.
There is none.
Exactly. There's no property owned by the person who died at that moment.
Noise has
Just,
questions.
is this the same as a trust?
No.
Well,
Okay.
let's get into that.
Okay.
Get to that.
Go to the next.
But interestingly, people do often mix them up because, at least in this context, it's a tool that's can be used for a similar thing. Trust has a lot more different, it can be used for many different things. Other than this, life estate really has this one use, really.
Gotcha.
So that's the way it works. And then the beneficiaries, whoever they may be, own as I say, it's real estate only. So I'm going to use the home as an example, own the home free and clear, doesn't have to go through probate, doesn't have to be looked at by the probate judge or distributed by the executor, or it's all up to whoever the beneficiaries are to decide what to do. Now, we'll get to this too, but remember this, can't forget in the background of this explanation is to think, remember, Medicaid, when it's trying to, remember that the idea is Medicaid is that if a person during their life had long-term care that was paid for by Medicaid, and then after they pass away, there's money in their estate that can be used to pay back Medicaid for the long-term care expenses that ran up while the person was alive. That's what that MERP is for, Medicaid Estate Recovery Plan. That's the whole idea of that, or of their purpose there, is to look at what's in the estate and try and recover. And in fact, from what I looked into this, I didn't realize this so much. Most often, that's the primary residence. Most often what they go after is the person's home, because that is, for many people, the main asset that they had. So if they used a life estate, can Medicaid recover that? No, it was never in the estate. So that's two purposes that what person might use a life estate for. Number one, you avoid probate, avoid all that time and expense. Number two, it's not recoverable by Medicaid,
It's not in the estate,
not
yeah.
in the estate.
So, when it's your primary residence, that's something that, while you're in long-term care, is not considered an asset that would be counted against you being eligible for Medicaid, right? Because it's protected. It's the only thing that's, anything else, any other asset is counted in terms of eligibility for Medicaid for long-term care, which your primary residence. So I suspect that, I mean, that's why a lot of these where Merck would apply is going after a primary residence, because they were able to keep it while they were on Medicaid. But then they can't any longer once they've died, obviously.
Right, and last time, we'll look at the rules too. I think unless there's some rules about when Merck can go after it. Like, for example, if the spouse is still living in it, they
Right.
can't do it yet, and that sort of thing. But generally speaking, yes, you have to, let's say, and I think it's I don't know for sure, but my guess is this number's been around for a long time, but $2,000 is the cutoff in assets that for eligibility for Medicaid. So in order for you to qualify for Medicaid long-term care, you cannot have any more than $2,000 worth of assets. I suspect that number has been around for a while, just because it seems so low these days, but I don't know for sure the exact date. I do know, interestingly, just that the fact that states have to have this MERP, this estate recovery plan, that was only 1992. Before that, it was discretionary. States didn't have to, but I think it was 92 is when that got a lot. But anyway, the point Representative Donahue was making is that when Medicaid is counting your assets to determine whether or not you're below that $2,000 threshold, they don't count your primary residence at that moment in time. So I think there are, again, some rules about as long as either you were living in it or your spouse or family member, there's some associated rules with it. But generally speaking, they don't count the primary residence at that point in time. If they do count it after you passed away, and they're looking at, well, what can we recover now? So then it becomes an asset that Medicaid can look to recover from for purposes of recovering the expenses that they paid on that person's behalf for long-term care while they were alive.
Because in theory, there would be nothing else that would be recoupable, because that would have all been taken before you become eligible for Medicaid. So the only thing that you would still have as a significant asset potentially after death would be your primary residence.
Yeah, or spent down. That's another thing that
You have to spend, right.
spend out. So let's say you had, just pick a number that's above $10,000, sorry. Or you had that amount in property that would count. And you're not able to get Medicaid long-term care because you have more than 2,000, right? Then you have to do what's known as a spend down. You have to spend that money somehow to come below the $2,000 threshold so that you qualify for long-term care. So you're right.
There's nothing left.
Nothing left other than your house.
Are there personal property? I'm sorry. Are there personal property exemptions? I've got my grandmother's brooch that has some value, things like that are not an IRA, they're not a 401k, they're not my savings account, CDs, et cetera. And to know if those.
It's a good question. Yeah, I'm not familiar enough to know that granular detail, but.
The long-term care Medicaid application is very detailed.
If
And
it's worth $5,000,
it'll be
I think
part of
it's,
that.
there's no,
They ask about vehicles, they ask about, there are some exclusions. So if you have a surviving spouse, even if you're, haven't put your home in a trust or haven't done a life estate deed, they can't claim that. They can't sell it and take the proceeds if there's a surviving spouse. So there are some exclusions to that, but if you are sort of a person who hasn't sought legal advice about how to protect some of your assets, which is kind of what Ann is talking about, then you essentially spend all the way down to that $2,000 level and you essentially become impoverished. And so you would qualify. And at that point in time, you would qualify not only for long-term care Medicaid, but there's many different sort of like doors to Medicaid. So at that point in time, you would probably qualify as a person of low income as well. So that, and it makes a difference on which door you walk through. It makes a difference which Medicaid door you walk through in terms of what you have access to in terms of insurance.
One point I forgot to make, which is interesting, is that in Vermont, it's true that the crucial point in time to measure or not whether your property in these is recoverable by Medicaid for purposes of their estate recovery plan is whether or not it was in the probate estate. That's in Vermont. That's not the case in every state. Vermont is what's known as an estate-only recovery state. So it has to have been in the estate. There are other states that use an expanded definition of estate, and they allow Medicaid to go after some property that wasn't necessarily in the estate, and that they're known as expanded estate states. And so it is actually go estate states. So I found it difficult to say 5 times fast.
Yeah.
But so there's 28 states that are probate only like Vermont, 22 that have this expanded. So it's a matter of rule, as to which one you state decides to be.
So just to clarify, on the enhanced life estate, my understanding when we put that in statute, which is only within the last 10 years,
Yeah.
You can actually still sell your property when you have that much control over it as a life estate. And so generally, under the normal rules, that would mean it's an asset to you still if you can sell it. But under Vermont law, in fact, it's still protected as if it weren't yours. And so it's still protected as an asset, even though you could sell it.
Yeah, I think that's
In
correct.
contrast to the general rule that, if you still have control over it, it's not really a life estate normally, but as an enhanced one, it kind of becomes another. Right.
Another, yeah, I
loophole.
think you're,
Yeah.
well, I leave the,
Yeah. Step.
oh, sorry, go ahead.
Yeah, that's why I wanted
Yeah,
to
yeah.
bring that up.
But no, that's correct, that you have more authority to dispose of the property now in a life estate than you used to have before the passage of that law. I think it was only 3 or 4 years ago, something like that. So the question of trust came up as well. So that's another tool that can be used. Because again, think about, this goes to the probate issue again. Remember, your probate estate is composed of all the property that you owned when you died, right? So a trust, when you put property into a trust, speaking generally for a second about trust, you have 3 parties in a trust. You have what's known as the settlor. That's the person who puts the property into the trust. You have the person known as the trustee. The trustee manages the property in the trust and makes distributions if there are any. And you have the beneficiary, and that's the person who receives the benefits that are distributed by the trustee. Technically, under trust law, the legal owner of the property is the trustee, not the settlor, not the person, like, for example, using the house example that you had. Someone has their house and they're like, well, I want to have, I'd like for my house not to be subject to the probate process because I don't want my kids to have to pay for all this expense and time. So some people will use a trust, some people use a life estate. Say you decide to use a trust. We already saw with a life estate, the reason that doesn't go through the probate process is because when the person dies, it immediately transfers to whoever the beneficiaries were, right? Never goes through probate. With trust, slightly different. The reason that doesn't go through the probate process isn't because it transfers. It's because technically the legal owner is the trustee, not the person, the homeowner who said, hey, let's dispose of my property through this trust. So never goes into the probate process. It's never, therefore, subject to the probate court trying to divvy it up. It's never subject to Medicaid going after the value of the house for purposes of paying back expenses that the person may have accrued when they were alive.
So, yeah, go ahead. Go ahead, Todd, first. I haven't asked anything.
I got a question. What if you have a trust already and rules change? Will your trust change? Is that written in stone?
Generally, it's governed by the rules that were in existence at the time you created the trust. So rules change would generally apply to trust going forward from the date of whenever the rules were changed. Now, we can make laws apply retroactively in Vermont, and it is sometimes done. It's a very specific way you have to do it. So let's say hypothetically, the rules change on the basis of a statute that specifically said it was applying retroactively. It's theoretically possible that it could look back, but generally it doesn't. Generally, it's what was the law at the time of the creation of the trust.
Thank you.
Yeah.
I had to.
Is it accurate that with respect to trusts and Medicaid, there's a look back period?
Yes.
So if I get a terminal diagnosis and I know that in the next year I'm going to be going to need care, I can't suddenly move everything into a trust. There's 2 or 5 or however many year look back period.
Correct. It's 5 years.
5 years.
60 months.
Used to be 2.
Yeah. Oh, did it used to be 2? I didn't know that. Right.
Yeah, it used to be 2. It changed to 5 quite a while ago.
Right.
Yeah.
Yes, so it's exactly right, and they will look into that. That's part of their jurisdiction as well, to see, you have to, if something was transferred, you can't say, I'm going to give away all the money in my savings account 6 months before I go into long-term care.
Yeah.
That's exactly what they're looking at. But interestingly, if for example, there's 2 types of trusts, generally speaking, revocable and irrevocable. Revocable trust, and the difference is just what it sounds like. If it's revocable, you have access to the property in the trust. Yes, the trustee is still technically the legal owner, but you have access to it. You can say, well, I want this distribution. I want that distribution. In fact, I want to end the trust, or I want to move this property in or this property out. Revocable trust, you can't do that. Once it's in there, the property is in there, it's up to the trustee. You do have authority. It's always interesting to ask for a new trustee. So if you're really unhappy with the way the trustee is distributing the property, you can try that route, but you can't do anything with the property. It's out of your control. It's irrevocable. So because it's irrevocable, Medicaid looks at that as not covered by the 5-year look back, because you can't access it. You really can't do anything with it. So they have what's known as, many states have a Medicaid, an MAPT, a Medicaid Asset Protection Trust. It's a specific irrevocable trust that people use to put something into it to not have it be recoverable by Medicaid. But it has to be very specifically done. It's not something that should be done casually. It has to comply with some very strict legal requirements, and you can't access it. It has to be irrevocable.
With no look back.
Correct. I think that's the idea.
Go ahead, Brendan.
Well, a lot of lawyers offer free workshops on trust, so of course I went to them.
Right.
Knowing me, trust is the way to go, but let's not go there.
Okay.
What my mother did, and a lot of people did, well, I learned young because my dad was really into this stuff.
Mhm.
Put your like a child's name on your accounts as you owe. Like I was on my mother's account.
Yeah.
And then when my brother wasn't paying his child support, he was on an account, and they tried to go after my mother. But of course, I wrote letters and stuff on my mother's behalf. So if you put somebody's name on your account when you open them, it's automatically the other person's account. So if people want to really think ahead, I'm already going to put my kids on my account.
Yes, that's another way
You just
to
got to
avoid it.
think ahead, because
Yeah.
the other person is automatically the account holder.
Right.
And a lot of my accounts, I put death benefit on. But you have to know that from working at a bank, but
Right.
a lot of
But that's
people
true.
don't know that.
Yeah. But I think you're right that more people are learning it, and then
Learning.
Yeah.
Put your children
Right.
on their accounts as you open them.
Right. So that way, when you die, you don't have to go through the process of trying to have the money in that account transferred to the child, because it's already yours.
So it's an interesting discussion, because you know, this country is obviously different than some other countries, and even state to state, you know, have some different rules, but I think that there's the, sort of this, I don't know, social question, if you will, about sort of the transfer of, generational, property, you know, to your children or your siblings or, you know, wherever it goes. And then the question of, well, then, should the public tax dollar be picking up your long-term care because you have, you know, you've done the things that we've just been talking about, you know, you know, there's lots of people who can argue in both directions. And in other countries, they have, you know, guaranteed long-term care. So it's not an issue in our country. It becomes a, you know, financial issue of the government. In other countries, like, you know, they pay for family leave and childcare and long-term care for older individuals if needed. So I think, like, you know, when Ann was talking about it, and when we're talking about this long-term care trust fund, trying to encourage people to plan ahead so that we reduce the reliance on Medicaid, I think is kind of like one of the goals. But it's also about being able to, you know, take some control over what happens with your assets. And so, you know, I don't know, it's an interesting dialogue that, you know, frankly, I can argue both sides of. So, which is, you know, it speaks more to the culture in this country, I think, than individual values per se. Yeah.
Just
go
a
ahead.
comment.
Yeah.
Thank you, Madam Chair, for raising that. I think the system kind of, when we're talking kind of high level and system wide, that also perpetuates inequities because people who are in the know, such as Representative Steady, can take advantage of a lot of those things, whereas people who are in poverty or immigrants, you know, people who are less advantaged, don't have opportunities to learn about these things.
Yeah, or any of us.
And then
My parents did it too. I mean,
Yeah.
they transferred their life as, you know, they did a life estate deed, so their property didn't, I mean, luckily neither one of them had to go into long-term care, but you know, they transferred their property to their 4 kids and, you know, there wasn't any probate, there wasn't any estate, and
So it just puts the burden on.
yeah, I mean,
Yeah.
there is disadvantages for people who don't, as you said, Brenda, people who don't know how to access those.
No, she said that. They do have access. All these workshops are very advertised, the free workshops, banks offer them. Just because you're poverty or an immigrant doesn't mean you're not a smart person. I stick up for everybody. They can read the paper, they can see the posts. These workshops are all free and offered to anybody, no matter their background, anything.
Yeah, I think I was referring to the comment you said that not all people know about putting other people's names on your bank accounts and things
Oh,
like.
I only knew that from working at the bank.
Well, that's my, I guess.
That's our point.
That's the point.
Yeah.
There are people with the workshops and.
Yeah, there's educational resources.
There's educational workshops, and these are some of the things that should be out there, but all these programs that help the immigrants, help the poverty, they should be helped. That's what they're getting paid for. And it's not happening, unfortunately, but
So there's the inequity that
there's the inequity of all the taxpayer dollars being spent on all these programs, and they're not working with the people to give them these advantages.
So when it comes to thinking about a long-term care trust fund that people would contribute to in some way, and the sort of intersection with, you know, trust law and estate planning law, what do you have any advice for things that we would need to think about?
I suppose without, maybe it isn't reached this stage yet, but I suppose it's still in the brainstorming stage, I
Yeah,
guess,
yeah.
right? then you would want to, any long-term care trust fund, you would want to think about, how does it, any assets or contributions that a person makes to it, how does that impact their probate estate, for example? Is our contribute, you would have to say, I would think, in the enabling language, let's say you got to the point where you were creating such a program, you would have to say something specific about whether or not funds that a person had contributed to that were either considered as part of their probate estate when they died, or subject to recovery by Medicaid.
Right,
And because if you don't say something, then who knows exactly
right,
how it would be treated.
right.
And I'm not even 100% sure. I think that is a matter of state law, but that would be an interesting question for the folks at Medicaid, over at Vermont Health Access would be, because, ordinarily I know they, by rule, develop their process for this estate recovery program. So is that something they would do by rule in the first instance, through the federal Medicaid law, or is that something that Vermont could do by say, hey, we're going to create this long-term care fund and we're going to set out these provisions?
That's an interesting concept about whether they could do that by rule.
Yeah, I don't know. Possibly.
But would it be any different than contributions one makes to Social Security, which is not, I mean, there can be a beneficiary, spousal beneficiary, but if I'm, 27 and I die and I've contributed to, and I'm single and I've contributed to Social Security for 10 years before I die, that's not part of the
Right.
estate.
Right. Yeah, it could be treated that same way.
Yeah, so I guess I had envisioned long-term care trust fund, or a fund that envisioned by this legislation, this bill, as being more akin to a Social Security and not necessarily
Well,
an
that's
asset of
how
the
the-
individual.
Yeah, I mean, that's how the bill is structured.
Yeah.
But I think there's probably multiple ways to envision it depending upon what the appetite is, or whether it's based upon individual's ability to contribute, or it's based upon a uniform contribution requirement from,
Sure.
anybody. Yeah, that's my other way of saying that, uniform contribution.
The T word. You see.
All right, and Eric provided the documents that both the state plan amendment, which that was actually pretty helpful. It's a pretty not easy read. It's got some complicated things, but it's just a 5-pager. And then what the rules are that Viva uses to implement that state plan. So those would be things to familiarize yourself with, just as general interest. But if we decide to do something with this bill at a later date, so.
I was going to point just to a couple of pieces of language in the
Great.
plan, just because it's interesting puts a little more detail on how this process works. So in the state plan, just for example, the Medicaid state plan that's online, if you looked at the very last page, which is
State plan, not the rules?
correct.
Okay.
The state plan. And the very last page. And you'll see A, B, C, and D there on the last page. So look at A and B. It describes this process. First sentence, all applicants for long-term care Medicaid are advised in writing about the Department's estate recovery policy at the time of the application. So anybody applying immediately is told, hey, just so you know, your assets could be recovered by Medicaid later on. And they might be subject to this estate recovery plan that Medicaid has. And it's on a specific federal form there that has to be, or sorry, state form that has to be there.
Oh, and then the probate court.
Yes, that's what I was going to say next.
Reports everything to the department.
Right. Subdivision B there. Probate courts report all estate openings to the department.
Right.
So again, and then what happens then? That's when we would move over for, well, it says right there as well. Claim is then filed against the estate of any deceased individual who was a Medicaid recipient meeting the criteria for estate recovery. So a claim is filed, right? Then notice is given to the administrator and the probate court and includes a copy of the department's regulations on estate recovery. So speaking of that, I'm just going to go for a second to the DEVA rules, because they are a little more specific. That's the other document. And that is in rule, it's on page 2, 7108.3. Pause a moment in case anyone wants to look at
Yeah,
it.
where is that?
It's on the page
The other
2,
document.
yeah, the other document.
Let me get, found this one.
Yep.
Okay. Got it.
All right, so go down to page 2. Estate recovery is underlined, 7108.3.
Okay.
Department shall, not may, department shall seek adjustment or recovery from the estates of individuals who died on or after January 1st, 94. So they shall seek recovery from the estates. Yeah, there's the language, could keep them up in that phrase, provided that the individuals are 55 years of age or older when they receive long-term care services paid for by the Medicaid program. For, it could be any one of these things, nursing facility services, home and community-based waiver services, admitted hospital and prescription drug services.
Yeah.
So a person has those services paid for by Medicaid while they were alive. After they die, department shall seek recovery from their estate. Right? And then go on to the next paragraph. The department will file a claim with the probate court as a creditor of the estate to recover its expenditures for long-term care services. So there you go. That's what they do. Remember, from the other rule, they get notice from the probate division too that this estate even exists. But they only do it, this is some sort of limitations on when they do it. Only after the death of the individual surviving spouse, if any, and when the individual has no surviving child who is under 21, blind, permanently and totally disabled. So there are some conditions there, exemptions, but that's generally how the process works. Key point there, though, shall seek recovery from the estates, right? So if you turned to the second to last page,
On that. Okay.
same, yep, in the same document.
Okay.
So just go to 70, at the very bottom of a page, you'll see 7108.33, adjusting claims against homesteads. Everybody see that?
Yes.
Just look at the first sentence. An estate includes all real and personal property and other assets listed on an inventory filed in the probate court. That goes back to my first point. Vermont is an estate-only state. So if you had some property that wasn't listed, for example, it was in a trust, you still have a property interest in a trust, but you don't have to list that because that was not owned by you, technically owned by the trustee. Or you might have an interest in property jointly with some other person that doesn't qualify. It's not on your inventory filed in the probate court, then it's not subject to recovery by Medicaid and is subject to this process that we were just looking at. Same thing is actually in the I don't think it's a document, but in that state plan on the first page, the definition of estate is there too. An estate shall include all real and personal property and other assets which are included in the estate when it is filed with the probate court.
That answers Doug's first question about if they have personal property, like coins and things like that,
Yeah, all
like-
real and personal
Right.
property.
Yeah, so Brenda and then Dan.
And then get back to Carafano. People of poverty or immigrants. I worked at DCF, they get all the benefits. They get an interpreter if they do not understand, or they bring in their children that. But they are offered an interpreter, and then maybe somebody of poverty that might not know what they're doing. They have the advantage of saying, I don't understand, and they can get help. So they are offered these advantages because I work there, and so I would hear.
Dan?
So in that, it talks about, assets listed on inventory.
Right.
Who creates the inventory?
That's usually the executor of the estate and the administrator of the estate, and then it's overseen by the probate division, the probate court.
The pain in the butt.
It is. Can be.
Yeah.
So if you're an executor, if anyone ever asks you, hey, when I pass away, will you be the executor of my estate? Seems easy enough, right?
Get it out of probate.
So in that situation, they go into the person's home and they go through all their stuff and make a list of everything that has any real value.
Yes, I should, ideally is one way to put it, but in some instances, just I happen to be an executor of a couple of people, so I know this. best case scenario, you've talked with the person before, while they're still alive, and they're saying, hey, will you be the executor of my estate? And you're like, okay, what kind of property have you got? Hopefully you'll go through, and they will say to you, this is exactly everything I have. Here's where it is. And here's how I want you to distribute it. And it's going to be in my will. Got these 3 kids. This person gets this person, and this is where that is. That person gets that. That is where that is. This person gets that. And here's where you find that. Doesn't always work out so easily, but that's the best case scenario. So that, yes, the executor does have to do that, compile that inventory. But if there has been the person whose property it was has thought forward enough, then you have all that written down beforehand.
And if the person has created a trust,
Right.
would they, or can they move stuff into a trust, like cars or jewelry or art?
Yeah, sure.
That could all be listed as part of the trust.
Yes.
So therefore, it wouldn't be subjected to this.
It wouldn't be part of the probate
It
estate.
wouldn't be part of the probate estate. It would be part of the trust.
Right.
And so, I mean, you can see kind of what the
Yeah.
loophole is. So, you know, the estate recovery rules specifically reference the estate. The estate is defined as what goes through probate, not as your ownership or, you know, partial interest or whatever in a trust. So, yes, people move their assets to trust, so they are not counted in an estate.
Therefore, they won't be recoverable.
It's subject to a 5-year look back period unless it's just unique.
Right. Right.
Whatever was long.
That's right. You're right. So you can't do that generally for with a typical trust unless it was more than 5 years ago, because otherwise they're going to look back and say, hey, you just put that into a trust because you didn't want Medicaid to get it.
Right. So it is the plan, it is the plan ahead version. I mean, you do,
Yeah.
there, yeah.
So if you have created a trust that's over 5 years old,
Correct.
and let's say 8 years later, you
Put something.
win the lottery, right? You move money or real items into that trust.
Mhm.
Do they automatically become part of that trust and not subject to the look back?
No, it would be subject to the look back.
So it's only what was in that trust within 5 years.
Correct.
Has to have been in there for
Yeah.
5
You make any transfer during that 5-year period is recoverable.
Okay.
And also one other, sorry to interrupt. I'm just going to add that there's an interesting question that I haven't yet been able to get an answer to. Hopefully I will, which is as I was saying, there's 2 types of trusts, revocable and irrevocable. If it's revocable, that means any property that you put in the trust, you can essentially move it around however you want and you can access it. Generally speaking, in most states, if it's revocable like that, if you still have access to all the property, then it doesn't count as a Medicaid exclusion. Medicaid can still recover it because it's not like you don't, you still have access to it just like you have any other property, right? It's
Regardless of how many years.
regardless of how many years, exactly. And this is kind of perfect timing, Representative Donahue, because I was just mentioning the question, which I don't know the answer to yet. But as most other states will then say in this revocable trust, Medicaid can still go after that because it's still like you're not really doing anything. You still have any access to it, just like you have access to any other property.
Right.
In Vermont, I'm not sure the answer because evidently Representative Donahue had some experience 7 or 8 years ago where in Vermont, this revocable trust was treated. Sorry, I should back up. On the other hand, there's this irrevocable trust where you don't have access to the property. Generally agreed that if it's irrevocable, and if you put property into that, as long as you've done it more than, actually, I think it might even not be subject to the 5-year window. That's what I was saying. But if you put property into the irrevocable trust, then it's not part of your probate estate, and then Medicaid can't get it.
And it does have the look back, just like if you give it away to your grandchild, doesn't work unless you gave it away, X years beforehand. I thought the trust was a.
You might be right, but there is an exemption to the look back.
Even met with a trust attorney at the time and all that. And it's like.
Right.
when my dad set up, he did a do-it-yourself thing, but when he set up this trust, they knew, they thought they knew, they knew that making it revocable meant that it did not protect assets from Medicaid, and they were okay with that. The purpose of them doing it was not to, prevent Medicaid from requiring it to be part of the buy down or spend down.
Spend down.
Their purpose was to avoid probate for getting things straight to the kids and all that. So they were okay with that. And when we went with my mom to talk about more imminent planning in later years, it was clear. I mean, the attorney was saying, well, of course, if you change this now to it not being revocable, it's too late.
Right.
It doesn't count because there's that look back period. We say, yeah, we knew that.
So let me correct something I said earlier in response to your question. So there was something that's not subject to look back, but I was wrong. It's not the Medicaid Asset Protection Trust. It's actually the Enhanced Life Estate Deed. So the traditional life estate deed did violate the look back rule because the beneficiary immediately had ownership rights. But an Enhanced Life Estate Deed, which is what you have in Vermont, does not violate the look back rule because the Medicaid recipient maintains ownership of the home during their life, and the beneficiary does not have ownership. So in other words, it's not a gift.
Right.
It's not. So it's not a gift that would violate the 5-year period that you made during that period. Like, hey, you were just giving assets away, but you're not really giving it away because you still have the authority, as you said, to sell it, mortgage it, do whatever you want. So that is a way that within the 5-year period, let's say you wanted to, even if it's only 2 years from now, that you pass away, or that you apply for Medicaid long-term care benefits, you want to put your house into an enhanced life estate deed, that you could do, and it would not be a violation of the 5-year look-back period, because it's not a gift under Medicaid's rules, because you still have access to it.
All this
That
is
makes
to
sense.
say
Sorry
that
for my
this
mistake
is
earlier. Okay.
really complicated.
It is complicated.
It's complicated.
Yeah.
And so, treading lightly and understanding what we're doing, is, something that's going to require a lot more testimony and understanding of the rules. And I'm thinking that we probably going to need some advice from people who are experts in this.
And it'll be a judiciary.
It'll be a
overlapping
crossover with
issue,
judiciary for
yeah.
sure, yeah.
Mhm.
So I just want to, especially at this time of year, thank Eric for making time in his
Thank you.
schedule to
Yes.
enlighten us about the nature of long-term care rules as it relates to estates and wills and trusts and all of that. It's pointed out that we have
Whole new topic for us.
points out we have a lot to learn. Let's just put it that way. So. it's
Am I good? I'll just because I wanted to check before I left, because I remember I mentioned this morning, this unresolved question of whether or not a revocable trust, whether the assets in a revocable trust count toward determining whether a person is eligible for Medicaid or not. I had sent an email to this person at DVHA who I was working with, and I'm like, I wonder if she got back to me while I was here testifying.
Yeah.
She did. Well, good morning. Our treatment of trust can get tricky, as you already know. When it comes to LTC, Medicaid eligibility for someone who has an interest in a trust. Even irrevocable ones might be countable to the individual depending on the terms of the agreement as it applies to them. If not the principle of the trust as a resource, then at least the interest dividends the trust earns as income. But to answer your question, yes, the assets in a revocable trust owned by an individual applying for Medicaid are fully countable as resources of that individual.
So there must have been a change.
Maybe it was a change in the last
7 years
Yeah.
because it was, yeah.
And
Yeah,
and I
go
just
ahead.
wonder about the ability of the state to actually, what's the capacity to go and look?
Yeah, they may not, no, because it doesn't show up in probate.
Right.
There's no way to,
Good point.
How
That would be
you?
a question for
how would you know?
Deepa.
that would be in the application. You
Yeah.
It's
can't-
in, yeah.
Yeah, you can't lie in an
I
application.
suggest that you take a look at the application if you're interested in this, just in your own time. having been through that with a family member, it's an extensive application for long-term care Medicaid.
Mhm.
You know, under the pains and penalties of perjury and all that kind of stuff, you have to list all of your assets, including trusts. So,
Sense.
yeah, so they know about it from your application.
Sure.
They know whether you've deceased or not, and they, I'm sure, check back on those applicants, and whether you had received any kind of substantial long-term care Medicaid benefit. And, yeah, so it's a, extensive process, and they take, you know, some period of time to process it. So it became an issue in Choices for Care for people who trying to access long-term care services who clearly didn't have much in the way of assets at all. And just because of they contact banks, they contact attorneys, you know, you're giving them authorization to do that when you're applying for long-term care Medicaid. So it's yeah, it's complicated. And, you know, I think one of the reasons that Representative Iacovone, you know, he's got a lot of experience in this field from his previous work, and both on the community side as a nursing home administrator, and he worked in the central office at the Agency of Human Services. So he's got sort of experience on both sides of the issue, and looking at ways to try to support, ways for people to try to support themselves. So thank you very much, Eric. We really appreciate it.
Yeah, definitely.
Especially this time of year when things get,
Yeah.
your ledge council schedules get pulled in many directions. So thank you very much. We really appreciate it.
You're welcome. Glad to help. Very interesting topic. And as you continue to work on it, if you have any more questions or if I can help out, just let me know.
I
Okay.
only took business long, so I've had to self-teach.
Okay. Thank you so much. Hi, Matthew. Okay, so we are now going to turn our attention to page 30, act relating to seclusion and restraint. You need a couple minutes.
I do need to take a couple of minutes.
We'll take a couple minutes to take a break.